Okay, we'll get started in a minute or two, if that's all right. Peter and Gregory, you can definitely still hear me, right?
Yes.
All righty, and we'll get started. Hopefully everyone out there can hear me. My name is Dennis Eisinger, and I will be predominantly giving this board member certification course. And I thank you all very, very, very much for attending and spending your time, both as volunteers for your community associations, as well as attending this program, which will give you a certification, but hopefully also will make you even better at doing what you do as board members. I would like to start with a brief introduction of myself. First and foremost, I'm very proud to say I'm a triple Gator, having gone to undergrad at UF, went to law school there, and I also have been teaching condominium and community association law at the law school since 2005. And very, very happy to travel to Gainesville to do that every week. And we also have a second home in Gainesville. In addition to the teaching at the UF, I am obviously licensed to teach this board certification course. I'm also licensed to teach a continuing education course to property managers. We'll call them CAMs for purposes of today, community association managers. I give that course from time to time for their continuing education. My law firm called Eisinger Law, our law firm, because I'm with two of the other partners of the firm today. It's been around for about 26 years now, and we have offices in Hollywood as well as in Gainesville. I've also been involved with development of condominiums in my life over the last several years, including student housing, a couple of condominiums by Depot Road for student housing in Gainesville. So with me today, and I think you can see them online as well, are two of our 5 or 6 partners in the law firm, Greg Eisinger and Peter Fox. Peter is actually the managing partner for the Gainesville office, which is located on 41st Street, really less than a mile from the Bosshardt location. You'll be hearing from them on a couple of topics in the next little while as well. So today we have many directors from both condominium associations and homeowner associations. So we're going to talk about both during the course of the course, keeping in mind that probably about 80–90% of what we talk about will be common to both. But we'll talk about the 2 different statutes in a few minutes, the Condominium Act and the Homeowner Association Act. We will, so we'll get to a chat. We'll talk about questions in a moment. I do want to take this opportunity to also thank Bosshardt-managed very, very much, and Gary Griffin for making this this possible for all of the board members of the community associations that Bosshardt-managed, and not only for making this opportunity available as an educational tool for you all, but also for what they do, what that company does with its managerial expertise in the Gainesville and North Central Florida area. Definitely, most or all of their managers really know what they're doing, and we're very, very proud to, when we're fortunate enough to have community associations in common for our firm and their management company. By the way, our law firm does represent approximately 650 community associations between South Florida and the Gainesville area. So we kind of believe we know what we're doing. We've been doing it for many, many years. Last introductory comment I want to make is that a little bit of a disclaimer or caveat. The Condominium Act and Homeowners Association Act is sometimes gets tweaked by the legislators every year during the 60-day legislative session. And the legislative session this year is going to end very soon. And just yesterday, the Senate signed off, unanimously signed off on a proposed bill over 100 pages long, making changes to the Condominium Act and the Homeowner Association Act. It's not law yet because it first has to be signed off on by the governor, and it also would not take effect until July 1st of this year. But there are many, many different, many changes to the operations of associations. I'm going to mention a couple or a few of them as we go, and assume that the law will eventually become law. But a real drill down into all the new laws we're not able to do today because, frankly, just came out late yesterday, and I've only just perused it very, very quickly. So with that introduction, let's go to, there's pictures. And there is the proverbial no legal advice and disclaimer as to accuracy of information. We will try to be as accurate as possible, but without knowing specifics of your particular association, sometimes or generally you cannot generalize and think that it always will apply to your particular association. So we give that little disclaimer. As far as if you have a question, we're going to take questions at the end, maybe some in the middle as well, but if you have questions that you want to put into the chat box, you can do that while I'm speaking. Greg or Peter will try to answer those questions for you. And then again, at the end of the program, we're going to certainly have sufficient allotted time for you to ask whatever questions you might have. So you navigate the chat box, nothing different than what you've probably already gotten used to on Zoom over the last 14 months. And first slide, this is relating to why we give this course. And we give this course because both the condominium statute and the HOA statute says that within 90 days after being elected as a director to a community association in Florida, you have to take this course, or you can sign a piece of paper that says merely that you've agreed that you've read your association documents, you will work to uphold those documents, and you will faithfully discharge your fiduciary responsibilities to the association members. So I greatly appreciate it when board members take the class because they're getting more education when you could have taken the easy way out and avoided taking this hour and a half, 2-hour class. So thank you. You will get certificates, whether most of you, I guess, are existing board members already, and therefore you probably already signed that piece of paper and don't need to take this course, but we're going to get you certificates of completion for this within the next few days anyway. They'll be emailed to you all. All right, condominiums, HOAs, co-ops. We're not going to talk about co-ops at all in this course because while we have some in South Florida, I don't think I've run across any co-ops in the Gainesville area yet. The difference between condominium form of ownership and HOAs. Well, for condominiums, it's property that is comprised of 4 different types of property. Condominium units, common elements such as the pool area or the roadways. Limited common elements are those that are common elements but exclusive use by one particular unit owner to the area, such as in the exclusive use of an assigned parking space or balcony or terrace. That would be a special type of common element called limited common element. The fourth type of property within a condominium regime would be association property in the unlikely event that the association owns something off-site, such as maybe a golf course or something. Every condominium unit owner owns their unit together with an undivided share of the common in common with the other unit owners within the condominium, and therefore the association owns nothing. The condominium unit owners own everything, their unit and the undivided share based upon their percentage of interest in the condominium. The Condominium Association is governed by Chapter 718, which is called the Florida Condominium Act, and we'll talk a little bit more about that act in just a couple of minutes. Quick examples of condominiums. Most of you probably are residing in a condominium or homeowner association, but there are many, many, many different types of condominiums. They could be residential, industrial, commercial, retail, dock slip condominiums, hotel condominiums, office condominiums, parking space condominiums they have in Colorado, horse stable condominiums, humidor condominiums, storage for vehicles, whatever. So while you may have only a certain number of type in Gainesville, there's a lot of creativity out there, and sometimes there is ownership of some very odd things. Cruise ship cabins, they're condominiums as well. So let's compare the condominiums to HOA form of ownership. For a homeowner ownership, the homeowner association is, and this is only for residential. You can't have a homeowner community governed by Chapter 720 unless it's residential in nature. And for a homeowner community, there are just the lots, the land where the house is built, or maybe it's townhomes that are connected or so. So the residential lots and association properties. Association property or common area property, such as the same thing, pool, roadways, maybe if there's a golf course or so. So Chapter 720 is the governing document for HOAs. That's generally called horizontal construction, whereas condominium living is generally called vertical construction. So the business of your association. It is a business, and in fact, for certain reasons, dealing with COVID, it's being defined as a business by the by state government as of the last week or so. But as far as I'm concerned, because the association entity is a not-for-profit corporate entity, both for a condominium association or a homeowner association, that it makes it a business to me because it's a corporation that's operating. So the community association, what's its main functions? Well, regulatory compliance and enforcement, enforcement of covenants and use restrictions, adopting and enforcing rules and regulations governing use and occupancy. The fiscal aspect of it is the adoption of a budget on an annual basis, inclusive of reserves. We'll talk more about that a little bit later. The imposition of assessments and the collection of those assessments from those owners who do not pay. And another fiscal responsibility is insurance. Insurance is very, very important, particularly for condominium associations, but also for HOAs. And I say particularly for condominium associations because usually the largest, biggest ticket item in the budget for a condominium association is insurance, because the association is insuring for the entire building. Inside the unit, that's really just airspace. And the unit owner might want to insure for their own personal property or fixtures within the unit, and the wall coverings and the flooring. Everything else, the structure of the walls, is insured by the Association for Casualty, for flood insurance, windstorm, whatever. Also, directors and officers liability insurance is applicable to both HOAs and condominium associations as well. So for HOAs, generally, not always, but generally, the insurance responsibility for the structure, the house, even if it's possibly a townhouse, would fall upon the individual homeowner. So that's why one of the main reasons that assessments in an HOA community would be significantly less than a comparable condominium association because of the insurance expense. Although, of course, the owner of the HOA unit or house obviously would have to then separately acquire insurance for themselves anyway. So what else as far as the business of a community association, the governmental organizational aspects, annual elections of directors. Maybe it's not always annual, you could have 2-year terms, but generally it's annual. Officer and director elections and responsibility, fiduciary responsibility of the directors to you, and we're going to talk about that in just a couple of minutes, because as a board member, probably the first question you should ask when you get on a board is, what does that mean? What's fiduciary responsibility? Am I going to get sued? And is there insurance coverage to cover it? And generally the answer is no, you're not going to get sued. It really is fairly infrequent. And there is directors and officers liability insurance, which we'll talk about. From the managerial standpoint, getting good management, such as Bosshardt property management, is always a very, very good thing, depending on the size of your community. But whether your community is operated and managed by your board of directors solely, or your board and a management company, you certainly have big responsibility with respect to the maintenance of the common areas and the limited common element areas. You also have significant responsibility with respect to the keeping and access to the official records of the association, written inquiries by unit owners and how they responded to and what type of time frame that you have to respond. Let's talk a little bit about, this is a list of some of the applicable statutes applicable to the community association industry. Just to say a few words about them. 718 we've already talked about. That was formed first in 1963 as a 5-page statute. The first Condominium Act in Florida. It was and still is a consumer protection statute. Most of it regulates the association operations, but there's also regulation of developers within it as well. Skip over 719, 720, the Homeowner Association Act. The developers were fighting having any type of legislation affecting HOAs until 1992. It was the first time there was an HOA statute adopted. And not surprisingly, it's much shorter. It's about 39 pages, whereas the Condominium Act today is about 120 pages. The 720 does not include any reference to developers and developer obligations, nor, most importantly for the developer, no warranties by the developer to the unit homeowners. Unlike Chapter 718, which does provide warranties for up to 3 years for new construction of the condominium, whereby the developer is responsible to the condominium association and its unit owners. Chapter 617, well, 61B, Florida Administrative Code, that's just administrative rules adopted for mostly the Condominium Act, because the only jurisdiction that Department of Business and Professional Regulation has, and I'll be referring to that as DBPR, Department of Business and Professional Regulation. They have a vast jurisdiction over many aspects of businesses in the state of Florida, including condominiums. For HOAs, the only thing that they could ever get involved with is disputes involving elections and recalls. Nothing else, no other jurisdiction. Chapter 617, Florida statutes, is the Florida Not-for-Profit Corporation Act, and where we don't have something specific in Chapter 718 or 720, and we look to Chapter 617 for other guidance as to rules and regulations applicable to the operation of your association. Chapter 715.07, I like to talk about briefly because it comes up, especially probably in Gainesville, applicable to vehicles that are illegally parked, and what you need to do as far as having signage and notice and whatever before you can tow a vehicle. So if the vehicle is located in a condominium setting, if it is located in a illegally parked place, you as an association can have the vehicle towed. But if it's a vehicle that's parked in the right place, but it simply is in non-compliance because, let's say, it's a truck and trucks aren't allowed, or it has lettering, or it's a disrepair, no wheels, whatever, well, that becomes an issue that you have jurisdiction on as an association. You can, it's a violation. You could have recourse maybe through the courts or DBPR, but you can't call the towing truck to tow a vehicle that is just merely parked in its right spot, but you feel it's defective. Best example of that is many years ago, I had an association, very zealous manager in South Miami who was looking through the condominium documents of her community one day, and she sees that it says no vehicle can be parked on, no trucks or commercial vehicle or any vehicle with lettering can be parked anywhere within the community. And she looks outside her window and she sees across the street, there's a police car parked there, and it gets parked there every day or every night because an officer apparently lives there. But she calls the tow company. The tow company comes out and she says, "You need to tow this vehicle. Look at my documents. It can't be there." The tow company says, "You are bad as a belfry, crazy lady," and they just, leave because they're not going to tow a police officer's vehicle. But during this conversation, the officer came out. I was just observing what was going to happen, and he's shaking his head, and he ends up going back into his house. About 3 weeks later, and this is ironic but a true story, the property manager sees another person pulling out of the community, and she recognizes who it is, and she recognizes that it's a person that she had sent a couple of violation letters to about his satellite dish being in an improper position on his balcony. So she runs out, she stops the car with her in front of the car, gets her hands up, goes to the side, the owner pulls down the window, she takes out a razor blade and she clips off the parking decal and says, "This is because you don't respond to me for the letters I'm sending." Well, this guy is screaming, his wife and 2 kids in the back are screaming. He pulls away, calls the police, and lo and behold, the officer that shows up is the one who lives across the street from the management office. And he, not really caring for this woman very much because of what happened 3 weeks before, throws her in jail, and she ends up in jail for a couple of days and then 6 months probation. So anyway, remember that if you're going to try to tow a car that's really not technically illegally parked. Construction lien law is very important for community associations, Chapter 713 of the Florida statutes, and that is used to protect the association from having to pay twice for the same work, as long as it complies with the applicable rules about filing a notice of commencement, posting it on the property for work, and ascertaining through that what subcontractors might be working on the roof job or whatever it might be for the community. So it also sort of protects, and if the association doesn't follow the 713 rules, it might have paid the general contractor disregarding the rights of the subcontractors and would have to pay again to the subcontractor. From the subcontractor standpoint, they are protected because then they have to send a notice to owner once there's a notice of commencement, notice to owner to the association saying, "Hey, I'm supplying the tiles for the roof, and don't forget about me when you pay the GC, because you have to also account for me and make sure that you get a letter from me that me as the sub has already been paid by the GC." So very, very important statute in the operations of a community association. 3, Chapter 468.431 is the Community Association Management Licensing Statute. So anyone who manages a community larger than 10 units or lots, or has a budget in excess of $10,000, and who is getting paid for what they do, has to be licensed by DBPR as a test, continuing education, background, etc., and has to be licensed in order to perform community association management duties. So you might be thinking, well, what about board members? Can you do all these duties that you need to do, adopting a budget, sending out documentation, whatever? Yes, you can do it because generally or hopefully you're not getting paid as a director and officer at your community. So if you're not paid, you're not subject to that law. Also keep in mind that there is exemption in that statute for someone who is performing functions for a community association that are merely administrative in nature. So you have an assistant manager or someone who's just doing things without authority, but taking complete authority from the board of directors. It's possible that that person does not need to be licensed by DBPR. Clean Indoor Air Act. We'll talk about that a little bit later if we have time. I'm a big proponent of no smoking in condominiums because there's a lot of buildings where smoke infiltrates from one unit to another. So I've been on a legislative kick for several years to try to get some legislation that deems secondhand smoke in a condominium regime to be a nuisance and a trespass and actionable, and to provide some type of remedies in the Florida statutes against that, and or to give condominiums upon a certain vote the opportunity to be declaring themselves as a no smoking condominium, or at least no smoking within the units. So anyway, that's probably also for another day. I glossed over Fair Housing Act, federal. That's a real quick thing I want to mention there. Gregory is going to be talking about reasonable accommodations under pursuant to the Federal Fair Housing Act and emotional support animals, service animals. But Federal Fair Housing Act is a little broader. It was a 1968 federal statute which said that it is illegal to refuse to sell, rent, or make housing available to anyone based upon race, color, religion, sex, or national origin. Those were called protected classes. In 1988, two additional classes came into being. One is prohibiting discrimination based upon age, and another based upon disability status, handicap status. Gregory will talk about the handicap status thing for age. I know in Gainesville we have the Oaks and a few other places that are 55 and older communities. That happens to be the principal exemption under the Federal Fair Housing Act as it was amended in 1988 to allow for the discrimination based on age. In other words, if you're a 55 and older community, which means at least 80% of the residents are 55 and older, then you can have something in your documents prohibiting children under the age of 18. Okay, next. Documents and statutes that typically govern the community association. We talked about the statutes already. The operative document for a condominium is the Declaration of Condominium, and then it's Articles of Incorporation, which incorporates the actual association entity, and then the bylaws, which really deal with a lot of the operational aspects for the association. You usually will have rules and regulations as well. For a homeowner association, same thing. Chapter 617, I'm sorry, 720. Declaration of Covenants and Restrictions is generally what the operative document is called for the HOA community. Again, bylaws, articles of incorporation, and rules and regulations. Governing documents will specify things we've already mentioned a little bit already. The duty to pay the assessment, and if you don't pay, the ability of the association, the very, very great power of an association to lien and foreclose that lien, just like a lender would foreclose a mortgage, and to force the unit owner to either lose their home or pay up the delinquent assessments. A very, very powerful remedy for all associations. Enforcement of use restrictions, rental and sale restrictions, architectural restrictions, particularly for homeowner communities. Bylaws is more operational in nature. Excuse me. Talks about the election process, although we'll talk about the election process a little bit down the road here, but in general, there is a very long, relatively convoluted election process for the election of directors for condominiums. For HOAs, it's basically, for the most part, whatever is in the HOA documents as your election process. Articles of incorporation, it's usually indemnification for directors in there. We'll talk about that too as a relative to a possible breach of fiduciary responsibility, and there is something called corporate indemnification for you as directors, and rules and regulations. The administration of the association. So let's talk about the hierarchy. So who's in charge here? The owners, unit owners, or homeowners in the community, they get to elect the board of directors. Board of directors, let's say it's 3 or 5 directors, they establish policy. They have their board of directors meetings and they establish policy, but the board, elects the officers, president, vice president, secretary, treasurer. And those officers have to implement the policy that the board established. So who's the highest? Well, the homeowners, is they control who's going to be on the board, but then operationally, it's the board members who actually have the power and they vote, and they just hand off and give specific authority, particularly to the president and the treasurer, to the officers as to what their role is in operating, governing the community. So the slide says that HOAs require a minimum of 3 members. Actually, condominium and HOAs, associations, by law require not less than 3 directors. And it doesn't have to be members. Your documents might say that anyone in the world could be a board member. Usually it will say they have to be a unit owner, but Oxford Terrace, the condominium I built by Depot Road, I did not provide that you had to be a member of the association to be a director, because the parents are buying for the kids. So very often maybe the title to the unit is going to be in the name of the parent, but the kid who's living in that community may want to be on that board of directors. So you don't necessarily have to be a unit owner, but it depends what your documents say. What if you go under the threshold of 3? Bad thing, because theoretically, if you don't fix that and someone raises an issue, then your association can be subject to a receivership, where a receiver comes in, holds an election, and in the meantime is doing all kinds of things, especially billing you for a lot of money. So if you get to 2, then you want to have the mechanism, which is generally an election, the vote of the 2 remaining board members for the election or appointment of a 3rd person to fill that spot. So always, even if the director wants to be very passive, always try to have at least 3 directors on your board. Okay, fiduciary duties. This is the important one. One of the important things we'll talk about. The officers and directors of an association do owe a fiduciary duty and responsibility to all of the members, defined many different ways, but on the left-hand side there, to act in the best interest of the members and the association as a whole, to exercise good faith, and to act with due care. So it's something hard to define, but it's something kind of, we know it when we see it, and we know it generally when we see it breached. In addition, and that's statutory. In addition, there are provisions in the Condominium Act and the HOA Act, which say that an officer, director, or manager may not solicit, offer to accept, or accept anything of service or value for which consideration has not been provided for his or her own benefit or that of his or her immediate family from any person providing or proposing to provide goods or services to the association. Board members, be very careful. Sometimes, most of the time, you're going to be looking after the best interest of the association, and and it may be your company that's supplying something that you're going to give it for almost nothing for the benefit of your association. But there are some rules that you do have to abide by relative to what you might be providing if you're going to get compensated in any fashion. The liability is a little bit amorphous, and I have found over the years that compared to other industries, because you're unpaid volunteers, it's rare that you do get sued. You have to really go across the line. And the main line is as follows. In order for there to be an actionable breach of your fiduciary responsibility, there needs to be an element of fraud committed by you, a criminal activity, or unjust enrichment. So if you committed a criminal act or a fraudulent act, then you breach your fiduciary responsibility. If you have unjustly been enriched, you've breached it. So example of the unjust enrichment. Let's say your condominium needs a new roof and you've gotten bids and everyone's bid $50,000, but you say, you're on the board, you say, oh, I know this guy, named John Smith, and I'll get a bid from him. And it turns out that you don't disclose it, but John Smith was your brother-in-law. But he comes in at $40,000 and best price and does a great job. So therefore, was there unjust enrichment to your brother-in-law or you when in fact you did a good thing for your community? Well, the answer is no under those particular facts. So you really ultimately haven't breached your fiduciary duty. You still have an obligation to disclose or disclose in voting, and there's a provision in both the Condominium Act and the HOA Act that talk about conflict of interest in voting. You need to disclose conflict. You need to get, once you've disclosed it, that you have a conflict, there needs to be a vote of 2/3 of the board members to approve the particular action that gives rise to the possible conflict. And then the unit owners or homeowners have the opportunity at a subsequent meeting to cancel out that action by the board that they just took when there was a possible conflict of interest or disclosed conflict of interest. So as directors, though, let's talk about the good part of it is how to minimize your liability. Number one, business judgment rule. Business judgment rule is a corporate statute and also codified in 617, 720, and 718. It basically says that as long as you are acting in good faith in a reasonable manner in which an ordinary prudent person would do, doesn't mean that you have to be right, because you're not going to be right all the time, but in your voting and your decision making, as long as it's not such an outlandish thing where you decide that you have like a little nursery on site and you're going to put a pedophile in charge of the nursery, something terrible, you will be violating your fiduciary responsibility. So you don't have to be right, but you have to just try to exercise good judgment. So that business judgment rule protects you most of the time, and you really have to be over the line before it's actionable. There is directors and officers liability insurance coverage too, which is something that if you're on the board, your association should carry it and pay for that expense. And therefore, if you get sued individually for something that you did, for relative to your association, that insurer will provide an attorney for you at the expense of the insurer and will defend you for that action. The insurance company, depending what you did, may or may not pay for damage that's ultimately adjudicated against you, because if you committed a criminal act or a fraudulent act, it may not be covered by your insurance policy, but the value of the D&O insurance policy is the free legal defense that it provides to you as directors and officers. So that's really helpful. Corporate indemnification, most articles of incorporation for associations provide for indemnification to its directors and officers if you get sued. However, that same fraudulent act or criminal act are usually exceptions in that indemnification. Rely upon your professionals. If it's insurance matter, speak to your insurance agent, financial, your accountant, legal matter, your lawyer, something that's kind of like on an edgy issue. Try to rely upon the professionals and get a CYA letter for yourself to ask the attorney or the accountant or the insurance company agent to provide a letter to your association as to what they recommend in a particular case. So if you have that letter, and even though you and the insurance agent or lawyer is wrong, then very, very, very unlikely you have any liability. Avoid the appearance of impropriety. Use committees to help gather consensus in decision making, and hire a good management company like Bosshardt. So those are a few good suggestions that I think that to minimize your liability. Collection of assessments. So we're going to go to Greg Eisinger now. Hey.
All right. Good evening, everyone. I'm Greg Eisinger, and before I get into the collection of assessments, I just want to thank all of the board members who have donated their unpaid volunteer time, which is often not appreciated by other residents, but the attorneys in this industry, the managers in this industry, we do thank you very much and recognize how much work you put into this job, essentially. And from the bottom of our hearts, thank you, because associations wouldn't be able to run without people willing to serve on boards. I'm gonna skip most of the bio stuff because I know this is a late class and we have a lot to cover, but just really quickly, I've been practicing for 10 years. I only practiced community association law. I now teach condominium law at Nova Southeastern University Law School here in South Florida. And while the bulk of my time is spent generally representing community associations, I also head the firm's collection department, the collection of assessments. And before I talk about the collection of assessments, there's been a few questions in the chat concerning the recording of tonight's meeting or course and the slides of the course. So if you would like a recording of the course or to obtain a copy of the slides, just email Josh Cole to obtain either or both of those recordings or the slides. His email is jcole@eisingerlaw.com. And then throughout the course, please keep sending the questions in the chat and either Peter or I will respond. So the collection of assessments. I like to analogize many aspects of community associations with our local, state, or federal governments. And as it relates to assessments, assessments are like taxes. The association passes a budget and then levies assessments to pay for those budgeted items. Now, a unit owner or a parcel owner, lot owner, regardless of how title is acquired, is liable for all assessments which have come due while that person owns the unit. And owners are also jointly and severally liable with previous unit owners for assessments which came due and were never paid by the previous owner. Now, this principle is a statutory in both the Condo and HOA Acts. So if a unit is sold and the assessments are still owed on this unit, then the property will not have clear title unless the assessments are paid prior to closing. Sometimes a property is transferred via a quitclaim deed, and then that new owner, the statute would kick in and the new owner would become jointly liable with the old owner for the unpaid assessments at the time the transfer occurred. Now, this is not always true, as some governing documents specifically provide that owners taking title to a unit are not liable for past due assessments. And if your governing documents are very old and do not contain something called Kaufman language, which will be discussed a little later, then there's a chance that the new owner would not be liable for the past assessments, and that debt would simply be wiped out from that particular unit or property, and the rest of the community has to make up for the budget shortfall. Also, if an association was the previous owner, whether they took title likely through a foreclosure, then the association is not jointly liable with that new owner. The statute, both in the HOA and condo statutes, they provide that associations are not considered previous owners, even if the association held title to that property. But for the majority of cases, owners are jointly and severally liable with the previous owner for past due assessments. I'd certainly recommend having your attorney review your assessment portion of your governing documents to ensure that the association can collect past due assessments from new owners. Also, the liability for rents and assessments may not be avoided by waiver of use of enjoyment of any of the common areas or common facilities or the abandonment of a unit. Once again, similar to a local, state, federal government, unit owners cannot just avoid paying certain assessments, taxes, just because they don't use the common facilities that the assessments are collected to maintain. I often see in some of my collection cases, defenses raised in a lawsuit saying, well, I don't use the pool, so I shouldn't have to pay the assessments to maintain the pool. or I didn't agree with the assessment to increase our landscaping budget, so I'm not paying for that increase. That's not how it works. Assessments must be paid whether the owner uses the common facilities or agrees with the portion of assessments. Assessments not paid bear interest at the rate provided in the governing documents or at 18% from the date due until paid. Now, if the documents are silent, then interest is 18%. However, most documents do provide for a specific rate of interest. So you need to make sure that you're charging the correct rate of interest, or your lien could be wiped out and the lien foreclosure action, if you're at that stage, may be dismissed. Same goes for late fees or late charges. If the documents allow, then the association may charge a late fee not to exceed the greater of $25 or 5% of each installment, but it has to be in your documents. This isn't automatically, if it's not in the documents, you get to charge $25 or 5%. This must specifically, unlike interest, be in your documents. And you have to make sure that your bookkeeper or accountant is following this procedure, because once again, if you're charging late fees and you're in a foreclosure lawsuit, the judge may throw the entire case out if you weren't ever permitted to charge late fees. Your claim of lien can be held invalid. Payments received must be applied first to interest, then to late fees, then to cost and attorney's fees, and then finally to the delinquent assessment. This is statutory, and it creates an accounting nightmare sometimes, but it has to be followed. If an account is delinquent and money is received, then the money must be applied in that order. All too often, when cases are in collections, the unit owners will pay the association directly instead of the law firm handling the collection case. And instead of applying the monies to interest and then late fees, then attorney's fees and costs, and then finally the assessments, the monies are directly applied to assessments. And then actually I came across this yesterday in a foreclosure case when I asked for an affidavit of indebtedness, how much is owed on this unit. And they sent me a ledger, an updated ledger. We're about to move for final judgment, and the ledger says nothing's owed on the unit. They've paid all their assessments. Well, now I'm going to go in front of the court and tell the judge, hey, they did make all the payments. This is the ledger, but they owe our attorney's fees. And sometimes a judge will say, well, you didn't apply the payments properly. And guess what? I'm throwing out your lawsuit. And now the association is stuck paying those attorney's fees when it really should have been the unit owner. So make sure that assessments, when they come in, are being applied properly. All right. So the association, speaking of liens, has a lien on each unit or parcel for the unpaid rents or assessments, interest, and late fees. The lien is statutory. So even if your governing documents do not provide for those lien rights, the Florida statutes do. Additionally, the statutes provide that the association's lien relates back to the date which the original declaration was recorded. And this is very important because, with the exception of unpaid taxes and first mortgages, the association's lien has priority over almost all other lien rights. And it's because of this relation back doctrine, which basically says, you know, the lien takes place, was recorded at the time your declaration was recorded. A few other things to point out about the association lien process and liens. Attorney's fees are secured by the lien if it's provided in documents. And in almost every single documents I've ever reviewed, there's a prevailing party attorney's fees provision, or it specifically says attorney's fees are part of the lien. A lien may not be filed until 30 days for condos or 45 days for HOAs after the association delivers a notice of intent to file that lien. The claim of lien must specifically identify the unit or parcel, the name and address of the unit owner, the name and address of the association, the amounts due, and those due dates. A lien is effective for 1 year from the date of recording. That's for condominium. So if you don't foreclose on that lien within a year, you have to start the process over. For HOAs, they don't have the same language where the lien is only effective for 1 year. We still recommend that you foreclose within a year. You don't want that claim of lien to linger for too long. but it's not the same as condominiums. Now, every association should have written procedures in regard to the collection process. My personal suggestion would be that management first sends a warning letter once an account is about 2 months delinquent. Then the account is sent to collections with the association's law firm once the account is about 3 months delinquent. The attorney will then send the initial statutory required demand letter, putting the owner on notice that a claim of lien will be filed if payment is not made within 30 days for condos, 45 days for HOAs. And then after that 30 or 45 days lapse, if payment is not made, a claim of lien is filed and recorded against the property. And then a second statutory demand letter sent advising the owner that a foreclosure lawsuit will be filed to foreclose that claim of lien if payment is not made within another 30 to 45 days, depending on HOA or condo. And finally, if payment's not made, then the foreclosure lawsuit is filed. Now, this policy or recommendation may not work for every association. Some associations may give their owners 6 months before sending an account to collections. They may give 2 or 3 warning letters, and others may choose not to give any warning letters, and as soon as something falls a month behind, they send it to the attorney. Whatever your association plan is, I suggest that it's placed in writing and strictly followed. All too often, associations have no plan and they forget to send delinquent accounts to collections. Then years later, when the association realizes that they're not consistently collecting the amounts needed for the yearly budget, they've been specially assessing to make up for that shortfall. They finally send these accounts to collection, and guess what? All debts that are more than 5 years old, assuming there's been no payments for 5 years, they're extinguished. I've gotten collection cases where someone sent me a ledger, an association sent me a ledger, and the unit owner hasn't paid in 15 years. Well, 10 of those years are extinguished. They can no longer collect. Also, if you're not going to be active in trying to collect your debt and unit owners get used to not paying, then those unit owners sometimes stop budgeting for association expenses. So when you do finally move for collections and the people haven't paid in 3 years, they don't have the money to bring the account current. And the final thing I want to talk about before turning this back to Dennis is you can't selectively enforce your collection process. Meaning you can't hear one owner's case about a hardship and say, you know what, I'm going to forgive that debt, you don't have to pay. And then another owner comes in and pleads a hardship and you say, well, it's not as bad as the first person. You can't do this. You can't selectively enforce your documents. It will cause great harm and animosity in the community. So now I'll turn this back over to Dennis.
Okay. Thank you. All right. Do I just add one last quickie little thing there relative to that analysis, which was terrific by Greg. But equity in the property is also an important issue. Maybe not so much these days because property values have been increasing, but during the recession, when there was no equity, we always in the collection process also have to balance the interest, determine equity, and see how far we can and should go in the collection process. So it becomes a thing between the legal counsel and the board to decide whether there's sufficient equity. Is that bank mortgage in foreclosure because they have largely priority over the association lien? So there's other factors too that always have to be considered. All right, so you see up there a list of official records of the association. That's for both condos and HOAs. And basically it's 16, 17 different items there. But the last one saying association records are, and all other records, basically paraphrasing. So almost anything within the possession of the association or the individual board members relating to the association, even potentially if it's on your own cell phone and texts or emails or whatever, would be association records. Now, not everything is always disclosable to all the unit owners or homeowners, but they are all the records. So the official records of the association are open to inspection by any association member at all reasonable times. And the right to inspect includes the right to make copies at reasonable expense. Reasonable expense basically is 25 cents a copy for condominiums and HOAs, but HOAs also have the ability to charge a certain amount for time expended in the collection of those association records for an owner seeking them, even though it's fairly nominal amounts. Association may adopt reasonable rules and regulations regarding the frequency, time, and location, and manner of the inspections, but the statutes basically say better has to be within 10 working days. And if not, there is a penalty to be paid by an association or a fine of up to $50 a day for up to 10 days if the association is not complying and not providing the records to the owner who requests it. That's the next item there. And the association must allow members to use their cell phone or other portable device in order to take pictures if the owner wants to try to avoid the 25 cent a copy charge. So there obviously needs to be records that not all unit owners or homeowners could get access to. So most everything, since the homeowners are the homeowners, they're the stakeholders, the shareholders of the association entity. But what is protected? Well, it makes sense that records protected by the attorney-client privilege or work product privilege, and any litigation between the association and either a third party or a homeowner, that would have to be protected from disclosure, because if not, it would be all that easy for someone who's suing the association to get all records and opinions and reports from the attorney who gave it to the association relative to the strategy of that lawsuit or so. So of course that has to be protected. Information obtained by the association in connection with the approval of a lease, sale, or other transfer of the unit, that's private information. Personnel records of the association or its management company, that is actually also protected as well. Medical records of owners is also protected. Social security numbers, driver's license numbers, credit card numbers, passcodes. The list goes on. All things that you would think to safeguard computer data, all that should be protected. Software and operating system used by the association. So those things, that list of about 7 or 8 different categories, and those, if someone's looking for the records of the association, they cannot get those. Really, as written now, the statute for HOAs and condos say that the owner does not need to have a particular purpose to get access to records, and they can be very broad about it. That was just reinforced as part of that 101 page statute that I mentioned in the very beginning of this course. They are attempting to provide more teeth for homeowners to make it a little bit easier for homeowners to get access to information from boards. Some associations are very, very free with that and very, very open. Some are not. Our experience is that board of directors and management companies in the Gainesville, Alachua County area are generally much fairer and following the law relative to this. In South Florida, maybe not so much, and more animosity and fighting, and we're not going to give it to them and whatever. So you can't do that. You got to follow the law when it comes to access to records, because the homeowners, whether they're paying their assessments or not, they are homeowners and they're entitled to the records. Association right of access to units. This really pertains to the Condominium Act more so than definitely instead of the HOA statute. And basically it says that in a condominium building, the units are on top of each other and you have common walls. So the association has a real interest to protect let's say there's a flood in one unit. Well, it's an emergency, so the association has the right to break into that unit and access that unit during reasonable times or during emergency to maintain, repair, or replace structural components of the building or mechanical or electrical components or whatever. So it just goes common sense that the association, board of directors, and management would have that particular right. That type of language is not in the HOA statute because in general that in the HOA housing is single family homes or maybe it's townhomes, but it's not as important. Talk about violations and remedies. Very, very important for you as board members to understand if a homeowner is violating rules and regulations, what is your remedy, what is your authority, and vice versa. The first part of this slide says that owners, tenants, invitees, as well as the association, are governed by and must comply with all the applicable statutes and the constituent documents. And then actions for damages or injunctive relief, or both, for failure to comply between association and owner, directors, or tenants. All those are on the table for possible remedies in the event there are violations that the association believes are being committed by an owner, or violations that an owner believes are being committed by the association for, let's say, failing to maintain and keep the pool open. The swimming pool has not been serviced for 6 months and it's all green with algae. So it goes both ways relative to possible enforcement action that might be applicable to your association. Greg had mentioned before in the context of assessment collection, a very, very important concept. The prevailing party is entitled to recover reasonable attorney's fees. So very significant. You can have the bargaining power matters. And sometimes the association, and sometimes the other way around, can have the bargaining position to make the other side spend a lot of money. Well, the check and balance on that is if the statute or your documents, this is statutory, both the Condominium Act and the Homeowner Association Act, provides that when there is legal action between the association and its owners, whoever initiated it, the winning party should be entitled to recover its reasonable attorney's fees and costs from the losing party. Sometimes the judge does not award the full amount, maybe you get 80% of it or so, but it's a heck of a lot better about winning the case. Yay, you stop them from swimming in the pool at the wrong time or maintaining a dog, but you just spent $10,000-$15,000 to do it that you're not going to recover. So the prevailing party attorney concept, very, very important. Here. What's another remedy that you have? Imposition of fines, both for condominiums and HOAs. The statute says that for condominiums that you can impose a fine after having due process. The board of directors has to impose the fine, and if the unit owner doesn't like the imposition of it, the unit owner could ask for a review by a grievance committee who's composed of individuals who are not board members or related to board members. And before the fine can be imposed, then the independent grievance committee consisting of owners within the community has to either approve or reject the board's action in imposing the fine. So good news, bad news, the fines are limited to $100 per day per violation, up to a maximum of 10 days. So theoretically, for a condominium, you can only get $1,000 worth of a fine for a particular violation. And condominium statute says that the fine, collection of it, is not lienable. You have to sue to collect it or put it on the ledger for collection down the road if the owner ultimately sells their unit or their property, but you can't initiate a foreclosure action to collect the fine. Let's compare that with the HOA statute. Very, very similar in a lot of respects. The grievance committee and the board authority and the $100 per violation up to $1,000. But the HOA statute says a couple of extra things. It says that if your HOA documents so provide that you can have that, instead of stopping at 1,000, you can have that cap at whatever you want. So if you keep on going to, I have one association down in the Keys where their cap is $20,000. And in fact, that cap was hit at one point a few years ago on a particular matter. And the statute further says that any fines in excess of $1,000 are lienable. So for a homeowner association, it's easier to collect that fine because the fine is lienable. One last thing about the grievance committee, due process, 14 days notice of what's going on there so that the homeowner has the ability to come to the grievance committee or the board of directors meeting and plead their case as to why that they should not be penalized and a fine imposed against them. So another remedy, in addition to the monetary remedy of fines, is the ability to suspend use rights for violating the rules and regulations of the association. Same process. The board of directors can impose it. The grievance committee has to either approve or reject it. The amount of the type of suspension for the use rights has to be reasonable in duration, and there are statutory provisions regarding that. There's also suspension of use rights statutorily if a unit owner is more than 90 days delinquent in the payment of their assessments. The board of directors would have to have a meeting and say, we want to suspend the use rights to unit number 101 until they pay their assessments in full. In doing that, they can suspend, basically what they're doing is suspending the use rights of the pool, the common areas, etc. You can't, as an association, you cannot take away the right of an owner to the access to the unit through the property, through the front gate, let's say, the access to utility service, parking rights, or use of elevator. So those four components are excluded, but you can otherwise have a rule where you suspend all other use rights. Suspension of voting rights as well. If an owner is delinquent more than 90 days in the payment of their assessments, and it's in an amount which is more than $1,000, then the board also, by having a board meeting and suspending, taking away the voting rights, and then notifying the owner or homeowner in writing as to the suspension, can also lose their right to vote until they are brought current. All right. The methodology for kind of going back to 3 slides ago about, I mentioned you have these remedies as an association for owners who are in violation. Well, right now we have 2 different mechanisms for initiating legal action to enforce the rights of the association. Under the Condominium Act, 718.1255 says that there's 2 different categories of infractions. And one category of infractions would have to go to non-binding arbitration before an arbitrator appointed by DBPR in Tallahassee. The arbitrations are handled by Zoom, or telephonically. So you don't have to go to Tallahassee for it. But for those categories where it is to be jurisdiction is through arbitration, well, it's through arbitration. Arbitration, though, is non-binding, and if either side doesn't like the results, they could then go to court and file a legal action saying, well, here's what happened with DBPR and the arbitration matter, but we don't like it, so we're asking you what you think, and we could initiate a lawsuit. The categories for what is a dispute that has to be resolved by arbitration or resolved to the best way possible, even though it's non-binding, is on this slide there. First part, a disagreement between 2 parties to take any action or not take any action involving the owner's unit or its appurtenances, or add to or alter the common areas or common elements, or second paragraph there, any dispute regarding the conducting of elections, giving notice of meetings, or properly conducting meetings, or allowing or not allowing inspection of records. Any of those categories right now would be handled through this non-binding jurisdiction of DBPR. Anything else, and the list is there, title, enforcement of warranties, levying of assessments, whatever, that goes directly to court. For HOAs, the process is different. And then we're going to come back to the condominium methodology in a second. For HOAs under 720.311, completely different process. Instead, the legislature provided that anytime there's a dispute, whether it's the owner against the association or vice versa, the party who wants to initiate action has to give the other side a letter saying, okay, I want to have mediation. Mediation being the process whereby people come in front, both sides come in front of a neutral person who effectively listens to both sides and tries to get the parties to agree upon a compromise. So that's the process of mediation. Mediator can't make a decision, yay or nay, but just tries to facilitate. Well, for HOA disputes, the process is mediation, and one side gives the other side 5 different mediators and says that you have 20 days to pick a mediator, and if you don't pick a mediator, then we're going to go sue you, which they have the right to do. So mediation, which I find does resolve a lot of community association disputes, is a great tool. If the person or the association does not respond within that 20-day period, then the other side can go right to litigation, or if it goes to mediation and it's not resolved in mediation, then you can have litigation, and then litigation is brought. So completely different methodology. So what happened yesterday is that the condominium form of resolving disputes was altered to the extent that it is now optional for the association or homeowner to go through that process of arbitration through DBPR. Now, for all disputes, the association or the owner can go directly to court. Probably a good thing, because although I like DBPR and they have some good people working for them, it's an extra layer sometimes of dispute mechanism, which thereby, one side wins, one side loses, and then the losing side is going to file a lawsuit anyway to contest what the arbitrator found. So I think they cleaned up their act pretty good, and they now have it as an optional remedy. Again, assuming that the governor signs the new law and it takes effect July 1st. Okay. Oh, vaccinations. I'm going to turn this over to Peter Fox now, who's going to talk a little bit about COVID.
Okay, yeah, hi, I'm Peter Fox in the Gainesville office, like Dennis said, and I've just got a few brief comments about the 3 topics on this slide. The first one concerns masks and whether or not community associations, whether condominium or homeowners, can impose requirements that people using the facilities wear masks, and the rule is yes, they can. And any mask rule would be subject, however, to a state or federal Fair Housing Act that requires what's called a reasonable accommodation if an individual makes a certain showing that they have a major life function that's impaired by the association's rule. There's some analysis for that, but basically it has to do with demonstrating that there is a need for an accommodation and that the accommodation does not impose significant costs on the association or make it impossible to operate the association. And so each request needs to be evaluated individually. It's definitely something that should be sent to a manager that's got an algorithm, or probably to an attorney to review, because there are penalties and there are attorney's fees associated with the prevailing party in a request for a reasonable accommodation if the association does not grant it, and it should have been granted. Then vaccinations, you're probably familiar with the governor's executive order number 2021-21 that prohibited the imposition of any requirement of proof by a business to, quote, gain access to, entry upon, or services from the business. And then this came out recently in the last couple of weeks. Dennis mentioned that associations are in fact businesses, or would very likely be considered businesses by courts in this context. And so associations probably cannot, in their common areas or as a requirement for membership in the association corporation, require that individuals prove they've been vaccinated from COVID-19 specifically, and probably any other public health emergent disease as well. Nevertheless, associations are free to impose, as businesses, screening protocols in accordance with state and federal law to protect public health. And these can include taking temperatures and asking about travel history and recent symptoms and things like that. And then those people could be particularly excluded on the basis that they are likely to be symptomatic carriers of the COVID-19. And then the executive orders, I think everyone's probably familiar now with the varying regimes of federal and state and local, whether it's county or city executive orders. These continue to change quite rapidly. Currently, the governor has extended the emergency order that was enacted in the spring of last year for an additional 60 days from yesterday. But there is language in this most recent extension indicating that he thinks the conditions are moving toward broader safety, with vaccinations becoming much more popular, and that probably the executive order will not be extended again, or at least not extended indefinitely. And then you have county and municipal orders. In Alachua County, the county commission has continued to impose mask requirements and capacity limitations on businesses and individuals. And they did impose fines, but the fines have been suspended by, again, order of the governor. And so right now there's no fining regime in place in Gainesville or Alachua County or any of the surrounding counties in the North Central Florida area that I'm aware of. But again, that continues to change on a weekly basis. And so we'll just have to wait and see when the actual emergency order finally expires from the governor's office. Well, that'll get back over to Dennis.
Hey, thank you. Thank you. That's a scary picture of that COVID thing. All right, let's go back to some more operational things, which I think would be of help to all in attendance here. Meetings of the board of which a quorum of members is present must be open to all owners. So that's the basic rule. You have a board meeting, you're talking about association business, and the members are entitled to be there, and they have to get their appropriate notice, 48 hours. If it's a board meeting, at the very least, unless your documents provide for more, or for membership meeting as well. I believe it's at least, well, whatever your documents say, but I believe it should be at least 10 or 14, if I'm not mistaken. So owners are entitled to be there to hear what's going on and to participate. If it's a board meeting, they may not have any vote, but they will have input. And if it's a members meeting, they may or may not have vote, depending on what the issue is. So the right to attend the board meeting also includes the right to speak at it with respect to all agenda items. So again, even though you may not have a vote as an owner, you have the right to express yourself. The association board could make reasonable rules and regulations as to the frequency and duration of the participation by the owners in speaking. Usually 3 minutes is a good rule of thumb. Owners may record or videotape the meetings or audio tape it. And let's talk about what constitutes a quorum of board members. So let's say you have 5 board members, and the 3 of them, well, you have 5 board members. Quorum is 3 then. The law says that all board meetings are open, and a board meeting, though, is defined as not just something that you send notice to, but something that you should have sent notice to. In other words, if you have a gathering of board members that are a quorum, 3 of the 5 get together, and they're playing, cards, or they're doing something, and all of a sudden those 3 start talking about association business. That technically violates the Sunshine Law, what it's called, the Sunshine Law as it relates to community associations, because you didn't send an invitation and a notice to all the owners saying that you're going to be playing cards with your buddies and talking about association business. So if 2 were there at that card game and start talking about association business, perfectly fine, because it's not a quorum. You didn't have 3 out of the 5. So again, this is one of these things that in South Florida happens all the time, and the owners are calling out their board. I know you're in there talking about association business, and that's violating the Sunshine Law, and it's illegal, and blah, blah, blah. Gainesville, it's a lot more civil, I believe, relative to it. But as board members, please keep in mind that you're not supposed to be talking about association business when you are in the company of a quorum of board members, unless it's a meeting for which there had been adequate notice posted on your property and were given to the other board members and homeowners. What that also brings up, or brought up a few years ago, is, well, how about if the board members are just communicating by virtue of a chat room or email communication? does that constitute a gathering of board members where they're talking about association business? Fortunately, the legislators came up with the right answer on that one about 3 or 4 years ago. And they said, no, if you want to do a group email, all 5 of the board members talking about a particular issue, you can. It will not constitute an illegally called board meeting. But you can't vote upon anything during that email communication. You can discuss it, you can get a consensus, and you can bring the issue back to the next time there's a board meeting and then have a vote. But you can discuss it on the electronic means without violating your responsibilities. So very important, the Sunshine Law. Keep in mind, in case anyone happens to have been involved with local government, city or county, there is Sunshine Law for that as well. And the Sunshine Law for counties and cities in Florida is no 2 council people, mayors, representatives of the city can talk about city or county business. Even if you have a commission of 7 people, 2 people could not talk about it, because the Sunshine Law for governmental purposes is no talking about anything unless it's in the public eye. So it's a Sunshine Law as well, but it's slightly different rule. Okay, notice requirements, 48 hours notice, except in emergency. That's for both condos and HOAs. Special assessments for condos and HOAs, and adoption of the budget. Generally, that would be still board decisions to adopt the budget, but it's not necessarily going to be a 48-hour notice, because you have to adopt explicitly for condominiums, impliedly in HOAs, 14 days notice to the homeowners with a copy of the proposed budget and the notice of the meeting that the board will be discussing the budget and possible vote on it on December 10th, 2021, whatever it might be. So that's a special meeting that has to be mailed to the owners, as opposed to a general board meeting, which generally, unless your documents provide otherwise, would just have to be posted in a conspicuous place upon the community property. Closed board meetings. So akin to what I mentioned before relative to the access of certain sensitive records of the association by owners, it might be a matter in litigation or otherwise. What if the board really needs to have a closed meeting without the homeowners in attendance? Are they allowed to do that? Well, as the slide shows, 2 examples, 2 times that they can. If there is a meeting between the board or a committee and the association's attorney with respect to proposed or pending litigation, possible litigation, if the meeting is held for the purpose of seeking legal advice, then that meeting can be closed and homeowners don't have to be invited to it. Technically, you're supposed to still post a notice saying there's a closed board meeting happening in 3 days from now, but it's closed because we're talking about existing litigation or whatever. But so you should post that notice, but if you don't, what you should definitely remember is that you as board members are allowed to have closed board meetings for that purpose. And you can also have a board meeting that's closed for purposes of discussing personnel matters. Maybe your own staff at your association, your own employee, or an employee at your management company. You want to hire a new management company, fire your existing, whatever, and that would also be permissible to have as a closed board meeting without inviting the public, the members, to that meeting. Board ineligibility, person who's been suspended, second, person who is delinquent in the payment of any monetary obligation due to the association. The third one there is if you've been convicted of a felony in the state and your rights to vote have not been restored, you are ineligible to serve as a board member. And those are pretty much the categories. Back, suspended, person delinquent in the payment of monetary obligation, convicted of a felony. I want to say there's one other one, I'm not thinking of right now, but Peter or Greg, can you think of one more category that you're up for ineligibility? maybe not. Okay. By the way, as I mentioned before, you do not have to be a member to be on your board if your documents so provide. Quorum requirements. Quorum for condominium meetings and HOA meetings are different. For a condominium meeting, if your documents don't provide for a lower number, then a quorum for your members meeting would be a majority of all the members in your community. For HOAs, because it's often much more difficult to convene a quorum and get people to attend an HOA meeting, the statute says that the maximum quorum you can require for your HOA is 30% of the owners. I've seen it as little as 10% in larger communities. A different quorum requirement for holding meetings of owners in an HOA versus a condominium. The election process for condominiums, monthly, as those of you who have been on your board, you have to send a initial letter out, 60 days, notice out to everyone soliciting candidates. Owners have the right to declare their candidacy, self-declare by providing notice at least 40 days in advance of that meeting. Then a ballot goes out with the names on it, and the election day comes, and there is a process for identifying all the ballots that came in, either by mail or those who were there in person, and a double envelope system that keeps it very anonymous as to who you voted for. And the process for especially larger condominium associations takes a long time to effectively validate all of the envelopes that may have come in voting for, which contain ultimately in an inner envelope the ballot. And that process is really good in that it is very private in nature, but it does take very long. There's a lot of due process involved with it. But again, in South Florida, there are numerous election disputes that occur in the connection with the election of directors, just like in real life, like the day after the election is over, for the next 364 days, that's election season again, because the directors are saying and doing things to potentially promote themselves so they can get reelected for the next year in some cases. At least that's my experience in South Florida. My experience in Gainesville area is just the opposite. People truly want to serve their community. They're very benevolent about their time. If they don't get elected, they say, thank you, have someone else do it. So very, very interesting how in different parts of the state we find different types of individuals who seek office as directors. In an HOA, the process is different. The statute says that to get that condominium form of ownership for election of HOAs, whatever the documents call for, however the meeting is going to be held, nominations in advance, people coming to the meeting and self-nominating themselves. They can adopt a condominium style election. So it's whatever's in your documents that counts. With one exception, the statute does say that no matter what, if there was no opportunity for a member to self-declare themselves or be nominated by a committee in advance of the HOA election, then there has to be nominations allowed from the floor at the election itself. So, significant difference between condominiums and HOAs when it comes to that. Annual election meetings, okay, that's what we just talked about. For the condominium election, for an HOA election, you can't have an election unless you have a quorum. Okay. So let's say quorum requirements, you have 100 people and you have 30 people who showed up, you have 29 people who showed up, you can't have an election. If you have 31, then you can. For condominiums, no matter what the quorum requirement is to hold an annual meeting of your condominium association, statutorily, you only need 20% of the unit owners to submit their ballots in order to have a ballot election. And again, that's a good thing, because if there's apathy, why should there not be an election? So the threshold established by the legislature is 20%. Electronic voting, it's starting to catch on in South Florida because we have some very, very large associations, particularly condominiums, that are going through the electronic voting. There's certain companies out there that allow for that to happen. It makes the voting instantaneous. So I would say it's probably only 5% or less of the condo associations in South Florida that have gone this way. But 5 years down the road, my guess is it's going to be mandatory in all associations in Florida for various reasons, including things like COVID. Reasonable accommodations and modifications, and turn it back to Greg.
All right, hello again. Just one more housekeeping item. Your certificates, so we don't forget at the end, your certificates will be mailed about 1 to 2 weeks after tonight. So don't worry, or they'll be emailed 1 to 2 weeks after tonight, so they should be coming. And then you can respond if you want. You can either respond to Josh when he sends you and ask for a copy of this, or you can email him beforehand. So reasonable accommodations and modifications. Oh, one other thing, there's been a lot of great questions that me and Peter are answering in the, I guess, chat. Hopefully everyone can see those questions. I'm not positive how it's showing up, if it's just going back to the person individually or if everyone can see, but if you could look at the questions, you can see some really great questions asked and answered. All right, reasonable accommodations. An association cannot impose additional requirements upon the handicapped, nor can it deny occupancy based on a disability. So essentially, associations must make reasonable accommodations to the disabled so that those individuals can properly enjoy their housing. So who qualifies as the disabled? Well, a disability is defined as something that substantially limits, impairs physical or mental abilities of a major life activity. The law provides that housing providers cannot discriminate against disabled persons and makes it unlawful to refuse to make reasonable accommodations to afford persons with the opportunity to use and enjoy a dwelling. Anxiety, depression, those may not be the disabilities that you're thinking of right off the bat, but those are considered disabilities, as well as physical disabilities, trouble walking and whatnot. So what are some examples of reasonable accommodations that must be made? Ramps for wheelchairs or people who struggle with chairs or with stairs. Parking space accessibility to ensure that a disabled person can park close to his unit or the elevator, or common facilities such as the community pool. Expanding doors, the door width, so an association may have to widen certain doorways if necessary. Installing handrails, or, as we'll discuss more in depth in a second, permit service or emotional support animals. It's important to note that handicapped persons must pay for the accommodation if it relates to their unit and access to it, but the association may have to pay for a common element accommodation. And to request one of these accommodations, the person living in the unit, it can also relates to tenants, all occupants. They must submit a request, either verbal or written, and there must be a relationship between that disability and the need for an accommodation. The accommodation must be based on a need and not a convenience. So if we're going back to the person who has anxiety or depression, and they may say, hey, I need an emotional support animal, that's reasonable, but they can't request a closer parking space or a ramp to be installed. There really needs to be a nexus between the disability and the reasonable accommodation. All right, so slide now on service animals or assistance animals. So there's a major misconception on the term service animal and emotional support animal. They're not the same thing. They're both considered assistance animals though. A service animal is any dog or miniature horse, and maybe you guys have some miniature horses up in Gainesville. I don't see as many in South Florida, but perhaps there's miniature horses that are service animals up in Alachua. And it's any dog or miniature horse that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Service animals are working animals. They're not considered pets. A seeing eye dog, or a dog that alerts an owner to take medicine at a certain time or helps the owner get up if they fall, that's a service dog, a service animal. Now, an emotional support animal is any animal that can qualify as an emotional support animal. And the Act does not require that an emotional support animal be trained or perform work in any way. The presence of the animal just naturally serves as comfort, emotional support to help a disabled person. So how do you determine if a person needs a reasonable accommodation to a pet rule? And the pet rules being, perhaps your community says there's no pets, or a person needs more pets than the community allows. A lot of condominiums or HOAs say you can have up to 2 animals, 2 pets, or a person needs a pet that's generally not permitted in the community. For instance, maybe someone wants a pit bull and there's something in the governing documents that say pit bulls are not allowed in this community. Well, if a need is apparent or obvious, then you're not allowed to ask the individual about his or her disability. And you cannot question the need for the accommodation. For instance, if someone is clearly blind and has a seeing eye dog, you're not allowed to ask further questions. That dog is permitted. If the need is physical, then you can request what service the animal provides. But if the need is not obvious, the mental or emotional disability, then the association is allowed to engage in a meaningful review and request certain medical documents and support, establishing that the person requesting the reasonable accommodation is actually disabled within the meaning of the law, provides a description of that needed accommodation, and provides information demonstrating the relationship, the nexus between that major life impairment and the requested accommodation. Now, I'm personally a major animal lover. I have 2 cats, 2 dogs, I have 3 parakeets, a terrarium full of praying mantis, and a pet duck who recently gave or hatched 15 baby ducklings, which are taking over my backyard. However, the concept of emotional support animals is now jading my view of pets altogether, especially in community associations, mostly in condominiums, but also in HOAs. People do take advantage of the ESA laws, and it's not difficult to obtain a doctor note which simply prescribes an emotional support animal that needs to live in a community with pet restrictions. Now, for clarification, it must be a doctor's note. You can't just go online and simply type in, I need a emotional support animal certificate and print that out and give it to the association. It really has to be a doctor's letter, which I'll talk about shortly. So what can the association do when they receive a request to maintain an emotional support animal? Well, associations can't ask for medical history, and they can't place an undue burden upon a person requesting an accommodation. You can really only ask basic questions, which were just previously discussed. What is your disability as defined by the Fair Housing Act? Are you disabled? Does your disability limit one or more major life activities such as sleeping, eating, living without fear, anxiety? And how will your emotional support animal help you cope with that limited life activity? If those 3 questions are answered, and I don't even believe the disability has to be labeled. You're not allowed to say, hey, what is your actual disability? It just has to come from a doctor that says this person suffers from a disability as defined by the Federal Fair Housing Act. So associations, if they do get a request for a reasonable accommodation, they must timely respond. The failure to respond or a delay in the response may be deemed a constructive denial, and the association could be sued. Associations should have policies, procedures for processing requests for accommodations in order to treat all the requests equally and avoid the discrimination. We do get a lot of discrimination complaints when either associations ignore these requests or the association denies these requests. It's becoming very common for owners or people requesting, tenants, prospective owners, to simply file complaints with the Human Rights Division in your county or the state. And these become a very big burden for associations. My most recent case that I've had to defend an association who wrongfully denied an emotional support animal request, the entire board and management was ordered to sit through, I think it was 5 hours of discrimination training. So on top of having to pay the person's attorney's fees and letting the person have their pet, board was also had to be trained through discrimination seminars. So what are some issues we face dealing with the emotional support animal requests? Well, as we discussed, breed restrictions, dogs with dangerous propensities. And even though a pit bull may be banned, for instance, Miami bans pit bulls. Federal law, though, trumps local law. So a pit bull, if it's deemed to be an emotional support animal by a doctor, has to be let into that community, whether local laws or your governing documents prohibit it. However, if the dog or any animal creates a nuisance, such as the dog doesn't stop barking or attacks other dogs or people, poses a threat against other residents, then the association can remove the dog as the danger or nuisance would override that other person's need for an emotional support animal. Other issues we face, the size and weight limitations. There's tiny condominiums where I've seen these 150-pound dogs be requested as an emotional support animal, and the association has to let them in, as long as it's not creating other issues in the community, nuisance or safety issues. Access to the property. Generally, you cannot restrict where the dog is permitted to go. Many associations impose dog walking areas. And as long as the area is reasonable, right outside of the unit, and it's not 1 mile away from the condominium, then it's likely going to be legal, but you can't restrict to burden the person where that dog is allowed to be walked or where they can go in the community. Competing disabilities. Let's say one neighbor needs an emotional support animal. It's a no pet condominium, and then the next door neighbor is allergic to that emotional support animal. Well, if the person with the emotional support animal cannot prevent the pet dander from traveling into the neighbor's unit, then that emotional support animal may need to be removed, and the owner may need to get a different animal because of the competing disabilities. And finally, multiple emotional support animals. I've had a request for 3 silky chickens, which I never knew what a silky chicken was. And we asked, well, why can't you just have 1? And the reason was the silky chickens actually need each other to survive. So the doctor's note prescribed 3 of them, and the association had to allow all 3 to stay there. If your association only allows 1 or 2 pets and someone has a doctor's note that says I need a 3rd pet, the association has to permit that. Thank you for everyone for coming. I'm going to turn this back over to Dennis, and I am going to take off as I have an 8 o'clock meeting I need to rush to. So take care, everyone. Thank you for your service, and I wish all of your associations the best.
Thank you, Gregor. I'm just going to have 2, 3, or 4 more random topics operationally that you might have some interest in here, and then we'll take any other questions. We'll open it up live. Authority to approve or disapprove of sales leases, an important issue. A lot of board members, associations think that all because it's in the documents that, hey, we could, review, screen, and deny you if we want. The fact is that even though it's not in a statute that I could point to, but by case law and common practice, there's only 3 or 4 grounds upon an association being able to deny a prospective buyer or tenant to buy or lease into that community. Number 1, if the applicant inherently does not meet a requirement within your documents. For example, the documents say no pets, and you say you're bringing 3 silky chickens and a dog, and that's what it says on the application, you can deny them because a basic provision in your documents would be violated. Number 2, if the prospect applicant has previously demonstrated a propensity to violate rules and regulations in that community, not the neighboring community, but that community, maybe the applicant was a tenant, now wants to buy a condominium unit there, but there was a long line of violation letters to that owner, and the association has firsthand experience with that owner and can prove that the owner was a bad apple, then that's probably grounds to deny. 3, and this is the one that comes into play way more often, the unit owner perjures or homeowner perjures himself or herself in the application process. So you ask questions, you have an application form, and if the owner or the applicant is truthful, well, you pretty much can't deny for anything. But if you said, well, were you ever judged a bankrupt? And you were, but you put in no, then that's grounds because they perjured themselves. Same thing for criminal background. Were you ever arrested? Were you ever convicted? The tendency might be to say no, no, but if the association gets a criminal report and finds out the answer is yes, yes, that's grounds to deny. And the final grounds that comes into play, which is just pursuant to a ruling from, I'm going to go up a step here, I think it's further on, criminal history. So you might say, well, how about if it was a really bad guy who, killed 10 people and went to jail? I used to say that, well, if they're honest about it, then they're still allowed in your community as long as they did not lie on the application. But now HUD came up about 3 or 4 years ago with some criteria that says, look, if it's a significantly onerous crime, murder, rape, sexual predator, or whatever, and depending upon the circumstances, there may be justification to serve substantial, legitimate, non-discriminatory interest to deny that particular person. So with the HUD guidelines has opened up the door to possibly disallow some who have committed crimes in the past, even though they admitted to the crimes and served their time, to be denied. But it's a dicey area. In one sense, associations have the upper hand on this because usually if you deny someone, even if you did not have the right to do that, the applicant is just going to walk away because they don't want to be in a community that they're not welcomed in. On the other hand, there's potential liability if you start exhibiting a pattern of discriminatory denials. So be careful when it comes to approval or disapproval of sales releases. Short-term, long-term lease agreements, transient occupancy, that's the Airbnb thing. And I'm still not sure we have it down pat for HOAs. It's generally not much of a problem or as big a problem, but for condominiums that requires minimum 6 or 12-month lease terms, yet someone buys a unit and uses it as a short-term weekend occupancy, and it's tough if you don't have a front gate for access control. It's sometimes very, very tough to regulate that. So we'll leave that for another time. Thank you. Okay. What else do we have here? Rental restrictions. The condominium statute 718.110 says that there's one particular right that you have, and that's a vested right to relative to leasing. So if you buy in a place and it said no leasing is allowed, and the association amends their documents to take that right away, well, it's not applicable to you per statute. The amendment taking away the right to lease will be applicable to all future owners because they're now on notice of it, not to existing owners. So that's the rule for condominiums. It's been in place since 2005, and therefore for any condominium association who desires to tweak with and make your leasing requirements more stringent, please keep that in mind. That will not necessarily solve your existing problem or issues, but it will ultimately down the road. The HOA statute does not have similar provision, or at least didn't until possibly yesterday. And I see that the same thing was added to the HOA statute as well. Same rule that I just mentioned for condominiums is now going to be in the HOA statute. It's a first refusal. Financial requirements, I am a big believer in, although there's no case law I could cite to, that when an association tries to impose financial restrictions such as credit scores or minimum down payments down on a purchase or whatever, they are probably participating in a discriminatory practice. You can't do it. It's arbitrary. It's subjective. And if someone doesn't pay their assessment, the association has their remedies. You could lien, foreclose, do whatever you need to do, but to set stringent or really any financial requirements, in my opinion, even though I have no case law to back it up yet, but eventually there will be case law that says that you're probably engaging in something discriminatory. Criminal transfer fees just went up to $100 per applicant to $150 for the new law yesterday. That's for new buyers or tenants in your community for condominiums and probably for HOAs as well. Security deposits, skip that. Questions? One last two things I want to talk about is MARTA, Marketable Record Title Act, and that is the law that hopefully anyone who's on board for an HOA right now is aware of. If your documents are 30 years or more older, when they got to the 30-year point after the recordation date in, let's say it was 1990, well, those documents expire unless they are preserved within the 30-year period. They go away. You don't have covenants or restrictions. You can't collect assessments. You can't make people paint their house. And those covenants go away by this law that was not necessarily intended for homeowner associations, but it is effective. It does not affect condominiums at all. Please keep that in mind. It only affects HOAs. And if you catch this before the 30-year mark, the fix is really easy. You do a preservation process, which costs less than $1,000, a board meeting, notice sent to the owners, and something recorded in the public records. Really, really easy and easy solution. Once you got to the 30-year mark, if you didn't realize it or your attorney didn't tell you about it, you have to revitalize your documents, which is a very convoluted, expensive process. You need 50% plus one of the homeowners to be signing something agreeing to the revitalization of your documents. And it's a real mess, and it'll cost you several $1,000s. So anyone in HOA, if you're out at that near that 30-year mark, please look into the date of it. And if you haven't preserved your documents, or if you've gone past the HOA 30-year requirement, reach out to your counsel or somebody, because you need to do something about it. Finally, Kaufman language was mentioned by Gregory a little before, and that's language that's contained within a set of documents, which basically refers to the applicable law to that community. So, Condominium Act, Chapter 718. If your documents say the law affecting our community is the Florida Condominium Act, Chapter 718, well, then it's Chapter 718. But it could say, or as existence of date hereof, or Kaufman language is Condominium Act as amended from time to time. The significance of those magic 6 words is, if you don't have those words in the definition, or whether it's the 718 or 720, it's not in there, then the law in effect for your community is the law that was in effect the day your declaration of condominium or your declaration of covenants and restrictions was recorded among the public records. So very, very significant impact of that on many, many different areas. So almost always it's better to have the current law in effect, because it's for operational purposes. It's almost always better in all throughout. And if you don't have that, or no one's looked at your documents to determine whether you have Kaufman language built into it already or not, my recommendation is that you amend your documents to incorporate Kaufman language, so that your 1990 or 1978 laws that are technically affecting you right now, which would be very minimal, would be updated to the 2021 version. With that, these are examples of where there's been cases as to why it's important to have Kaufman language in it. Collection of assessments, terminating condominiums, term limits. Term limits for condominiums, by the way, is now 8 years, and the new law yesterday says that law, when they put that on the books about 3 years ago for term limits, no one knew if it was retroactive or not. The new law clarifies and says it's not retroactive, so it goes from 2018. Anyone who's been on the board for 20 years, you can still stay on your board in a condominium setting from 2018 to 2026, which is 8 years before you'd have to vacate your position. Anyway, I think with that, I am going to see if there's any questions. So how do we unmute you? Questions. Peter, do you know how we do this?
I do not, but I can, we can go through the questions that are still pending in the Q&A if you want. I can read them out and you can answer them, and then people can just type their question there.
Okay. Sure. Let me just kind of check with Josh for one quick second.
Okay.
Josh? How do we? Okay. Okay. We have a logistical issue, which was a little mistake here. We have a meeting that Gregory is conducting is starting right now, and it was scheduled with this very same Zoom link. So we're going to have to end this thing. I apologize. Feel free to reach out to Gregory, myself, or Peter with any questions that you have. I'm sorry, we're going to not be able to have our question and answer thing, but we will be very open and helpful with whatever questions you might have. Not tonight, but starting tomorrow, reach out to any one of us, okay? Hopefully you enjoyed the program. Sorry, we have to abruptly end it right now. But we got to do what we got to do, and I thank you again for your service as, on the board of directors, because you're the true volunteers, and greatly appreciate it from the bottom of my heart too. All right, so we'll sign off. I don't know how to do that.